Today we're talking about the lawsuits that will likely follow the implosion of OceanGate's Titan submersible, where unfortunately the 5 passengers on board tragically lost their lives. Naturally, the waiver that the passengers sign will be central to any legal proceedings that commence. A waiver is an agreement in which people can waive certain rights, including the right to sue for injury, loss, damage, or even death. Importantly, the OceanGate waiver stipulates that the Bahamas is the jurisdiction that governs the waiver. That means if there's a dispute in relation to the waiver, the laws of the Bahamas will apply. I've heard some people on YouTube talk about waivers in the context of US law. However, as the Bahamas is a common law jurisdiction based on English common law, negligence alone can render the waiver unenforceable, whereas the United States is more likely to enforce waivers. Correct me in the comments below if you wish, any US lawyers. I've also heard people speak about gross negligence as a separate concept to negligence. Again, under English common law, negligence is negligence, at least under the tort law, which allows people to sue one another. In fact, in a Bahamas Supreme Court decision, counsel referred to an English case of Armitage and Nurse, where Lord Justice Millett described the difference between negligence and gross negligence as a difference of degree, not of kind. Now, I want to point out that there is, in the UK at least, gross negligence manslaughter in the criminal jurisdiction. However, today we're talking about lawsuits under civil law, as the Bahamas will have no criminal jurisdiction in this matter. Now, those who have signed the OceanGate waiver agree to accept all risk of the Titan voyage, including risk of death. They also agree to hold OceanGate and others involved in the voyage harmless from lawsuits. On signing, the passengers also acknowledged that the Titan was an experimental vessel. Now, to be successful in a negligence proceeding, the plaintiffs must prove that the defendants owed them a duty of care, that the defendant breached that duty of care, and that the plaintiff suffered loss or damage due to that breach. Courts will also consider whether the incident was reasonably foreseeable. And this can get a little complex, because a lot of people would say, of course it was reasonably foreseeable. The passengers knew the risk because they signed the waiver. Now, we'll talk about what the passengers knew in just a minute, but first, let's deal with what OceanGate knew. You see, if the plaintiffs can prove OceanGate knew or ought to have known there were significant safety issues, then it will be easier for the plaintiffs to convince the court that there was negligence. And we know there were plenty of warnings to OceanGate. In 2018, OceanGate filed a lawsuit against David Lockridge, who countersued, accusing the company of ignoring his repeated safety concerns about the Titan, which he documented in a safety report when he was employed by the company. According to Mr. Lockridge, the report questioned whether the submersible could withstand the pressure at 4,000 meters below sea level. In his report, Mr. Lockridge also recommended conducting non-destructive testing for passenger safety, but he argued that OceanGate dismissed his recommendations. Mr. Lockridge also claimed that the viewport of the sub was not certified for the planned depth, and that OceanGate refused to invest in a certified viewport. Additionally, Mr. Lockridge claimed he was fired for raising these concerns. Unsurprisingly, the lawsuit was eventually settled out of court. But Mr. Lockridge wasn't the only one who raised safety concerns about the Titan. Famous movie director and experienced submersible adventurer James Cameron appeared to be aware of the risks.
I had deep concerns about the technology that they were using, composite fiber wound filament hull, which I don't believe has any place in deep submergence.
I've also recently interviewed adventurer and astronaut Nick Halleck, who said that his friend Richard Garriott warned billionaire Hamish Harding not to go on the Titan voyage before the dive.
Basically, my friend Richard was at an event with them in the Azores, in the Indian Ocean, and basically said, you know, he was trying to convince them not to go on this particular submersible because of the dangers or whatever to it. So
if you haven't seen that video where I interviewed Nick, I'll leave a link in the description below. Make sure you watch it because Nick reveals some incredible and very startling information that will blow your way. Anyway, there are numerous experts and people in the adventure community who had significant safety concerns for the Titan. Getting back to the passengers, were they aware of these issues? I mean, you got to ask, did the passengers accept the waiver with the knowledge that there'd been so many warnings by experts? Or did they agree to the waiver on the basis of what they read on the page? Also, at what point were the passengers asked to sign the waivers? Was it at the time of booking the dive, or was it shoved in front of them immediately before they boarded the Titan? Look, it may be a moot point if OceanGate is found to be negligent, but believe me, the lawyers will be reviewing everything to get the full picture because they want as much ammunition as possible. As you can imagine, without all of the information, it remains to be seen what the next steps will be. Maybe they're going to wait for the investigation to be finalised before filing. That said, the family will likely have numerous experts to call on to help them establish negligence. But there'll be a lot more to this than just negligence. Lawyers will also be considering whether there was any criminal negligence in the United States. US lawyers will also be investigating breach of contract as well as safety maritime and maybe US consumer laws if they want to pull the matter back into the US jurisdiction. Then again, maybe they'll be happy to bring a negligence action in the Bahamas where there are more favourable laws to strike out the waiver altogether. The real question is money, and by the time a proceeding commences, will OceanGate have any? So I'll be expecting the lawyers to look very closely at the insurance policy, that is, even if a policy exists. Believe me, nothing would surprise me at this point. Another thing, I suspect lawyers will be exploring legal action against the estate of the captain, Stockton Rush, personally. So what does this all mean for OceanGate? Well, I don't think the company can go on. The outcome of the lawsuits will ultimately depend on the interpretation of the law, the jurisdictions, the submersible safety, any criminal activity, negligence, the knowledge of the passengers, the result of the investigations, and of course, I'll look at OceanGate's specific actions, the solvency of the company, and of course, the insurance policy. Also, who knows if any third parties will be added to be another defendant, such as the carbon fiber manufacturer, for example. So that's it for today. Tell me what you think in the comments below. I'd really like to open a discussion and hear your thoughts. Remember, stay informed, stay curious, and always stay legally savvy. And remember to hit like and subscribe so you can get notified of more thrilling legal content. Until next time, thanks for watching and we'll catch you in the next video.